Just because they beat you to the punch doesn't mean that you don't have evidence of domestic violence and that you're not due a restraining order. I've had many restraining orders where the guy filed second, or they came to me and I said, look, you need to file, right? And we filed, and where the restraining order's been against them, and then we flipped it, and we ended up that trial with the domestic violence against the other party.
What is going on, everybody? My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. And today, we're finally here. We have part 6 of a 6-part series we've done about all things domestic violence restraining order. As with the first 5 episodes of the series, we have partner here at Real Father's Rights, Ryan Dreyer, here with me. Ryan, how are we doing?
I'm awesome. Thanks for having me once again.
Awesome. And so today, to kind of put a bow on things, we've talked about everything from the TRO to the burden of proof to evidence to being a witness and really everything in between. Now we're going to talk about really another tool or something else that is a lot of times can be very key in the defense of a restraining order, and that is filing a competing domestic violence restraining order. What do we mean by competing domestic violence restraining order? This occurs when one party files a restraining order. A lot of times that restraining order, the temporary, is granted, and the other party goes in and files their own restraining order. So both parties are requesting a restraining order against the other party. Because a key fact that a lot of guys don't get sometimes is restraining orders are unilateral. If you are restrained, if a TRO is granted against you, you may be restrained from communicating with her, but she is technically not restrained from communicating with you. Now, does that cause some issues if she is for her in her case? 100%. But restraining orders are unilateral. So I think we've seen really over the last 12 to 24 months an increase in the number of competing restraining orders.
Correct.
And usually what keeps the number of competing restraining orders down is that guys simply don't like filing for restraining orders. So Ryan, I want you to go over what's kind of the common situation and the logistics you see when filing a competing restraining order makes sense.
Well, simply put, when there's been domestic violence or a history of domestic violence, a lot of times the other side files because they know that they've committed domestic violence. And it's kind of like a peremptory. They get ahead of the issue and they file first. Because let's be straight, whoever files first, if there's kids, they're going to make a order, generally no contact or monitor supervision to the guy. And then they're going to file, and the judge will grant theirs as to contact between the two, but they are not going to change the custody order. This is where we've got to come back to all the time. Oh my God, she has committed so much and I have so much evidence and I have all of this. And if there's just a unilateral restraining order, you're going to try to bring that stuff up. And the judge is going to say, that's not why we're here today, man. We're here today on their specific allegations of abuse. And now, if you haven't filed that restraining order, the judge is going to rule it to be irrelevant. They're going to rule it to be, you know what? We're not here for that today.
Unless you have one. Unless it is specific to the instances they are alleging.
Correct.
Any other instances where she's perpetuated domestic violence are irrelevant.
Yeah, your picture of a black eye that's not included in her allegations, not going anywhere. And so remember, a lot of guys will say, well, now if I file, it just seems retaliatory. You can get around that. Yes, that's a fact that someone will point out, anyone will point out. Well, they only filed because I filed. But that's why if you have the evidence, if you have everything else, well, then you're going to get past that right away, right? Don't let just because they beat you to the punch, I know that's a bad term here, but just because they beat you to the punch doesn't mean that you don't have evidence of domestic violence and that you're not due a restraining order. I've had many restraining orders where the guy filed second, or they came to me and I said, look, you need to file, right? And we filed, and where the restraining order's been against them, and then we flipped it, and we ended up that trial with the domestic violence against the other party. Right? You're undercutting yourself. If there is domestic violence, and I'm not saying make a false filing. Absolutely not at all. But usually, Mother Teresa doesn't marry Charles Manson, right? There is going to be mutual combat. Usually, if there's a drug issue, there's drug issues on both sides. Usually, if there's abusive language, there's abuse on both sides, right?
Well, there's stats that even say that, so women are usually victims of physical domestic violence anywhere from 6 to 7 times before they report. Men are victims upwards of 15 times before they report. So usually in these situations, especially when it's pretty nasty both ways, both of them have been victims of domestic violence on numerous occasions.
Right, and under that, when we have that, the judge needs to look at who is the dominant aggressor, is the principal aggressor. And remember, that can switch from incident to incident. And sometimes you may very well end up with both of you having a restraining order against you. But that's still much better. That's still keeping you on equal footing with the other side, right? Because now we're looking under the family code, and I know we've done a lot of videos, family code 3044 presumption, right? If we have only one person who has a finding of DV against the other, what does that mean? That means pretty much almost always no joint legal and joint physical custody, right? Sole physical, sole legal to the other side. If we throw that in, all right, we at least put ourselves on equal footing, right? Yeah. But again, too many guys, it's a pride thing to them.
Yep.
They don't want to admit to their friends, to their family that this occurred. I mean, I have seen so many men that have been beaten down for years, and they start off with small contacts, maybe a slap, maybe some other things. Remember, she slaps you, that's domestic violence. That is enough for a woman to get one against a man. And the inverse is true, guys. We've got to get out of these gender roles that you just have to take it or you should have known better, right? If there's domestic violence, bring the restraining order. Bring it early, bring it often, right? But don't just accept that, oh, the court's not going to believe me because she's smaller than me and I'm big. No, I mean, if you have pictures of your black eye, if you have the crazy texts, if you have video recordings, all of these, you need to marshal those and bring those in with, again, remembering if you don't bring it up, you're not going to be able to present it at court. It's going to be a one-sided affair and you're going to lose.
Yeah.
If you don't allow yourself to, I guess, show some weakness and then, yes, that occurred to me, right?
Yeah, definitely. So thank you so much, Ryan, for providing some context around the dueling restraining orders and I guess what we both kind of view as a proliferation of those in family courts. To our listeners and viewers, we have come to a close. Part 6 of our 6-part series on domestic violence. If this is your first episode, like I said in the beginning, go look back on your podcast feed or in the YouTube playlist and watch the other 5 videos. We've covered everything from TROs to evidence to witnesses to what is domestic violence, all the way to dueling restraining orders. We hope you found this informational and educational. My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook.